Hello and welcome to one in a series of webinars EPA is running in the lead up to 1 July and the commencement of the Environment Protection Act 2017. My name is Claire Moran and I'm a Senior Program Manager in our Regulatory Standards and Enforcement Division. Some of you I have met or emailed during the past almost 2 years that I've been working on this topic. I hope you will find today informative, and I want to say thanks to many of you who have provided feedback over that time to help us get to where we are today. EPA values our working relationship with local government. You are our partners, you jointly regulate under the Environment Protection Act with us, and you are duty holders, meaning you have obligations under the Environment Protection Framework. Today's webinar aims to prepare you in your role as a joint regulator as we head towards commencement of the new Environment Protection Act on 1 July this year. EPA acknowledges Aboriginal people as the First Peoples and traditional custodians live, work and depend. We pay respect to Aboriginal elders past and present. I'm coming to you today from Wurundjeri country. As Victoria's environmental regulator, we pay respect to how country has been protected and cared for by Aboriginal people over many tens of thousands of years. We recognise the unique spiritual and cultural significance of land, water and all that is in the environment, and the continuing connection and aspirations for country of Aboriginal people and traditional custodians. The image you see on this slide is EPA's Aboriginal inclusion symbol, the Guyam Willem Shield. It was commissioned by EPA from Wurundjeri artist Mandy Nicholson. It signifies protection. I would like to remind you that this session is being recorded. The recording, slides and relevant links will be made available to all who have registered today. The best way to communicate with our support team is through the Q&A feature at the right of your screen. If you would like to access the closed captions, you can switch them on at the bottom of this video window where it says CC. We're so pleased there's been such an excellent response to this event, with over 680 people registered and over 45 pre-submitted questions. The information presented in today's webinar is provided as general guidance only. It doesn't constitute legal or professional advice and shouldn't be relied on as a replacement for consulting the laws directly to understand how they may apply to you or your council. You should obtain professional advice if you have any specific concerns. Now to the agenda. We have 3 different speakers today to focus on the key topics where council are empowered to regulate under the Act. I'll be taking you through on-site wastewater management systems. Then I'll hand over to Will Mosley, who's one of EPA's Officers for the Protection of the Local Environment, to talk about residential noise. Following Will is Claire Dawson to talk through litter and other waste. Some of you will know Claire as our lead developer of the 3 toolkits, which we'll be talking to later on. We've had an excellent response to this webinar, as I mentioned, with over 680 registrations and over 45 pre-submitted questions. We have allowed time for questions after each topic, and we have tried to address many of the pre-submitted questions in our presentations. We have also selected the top 5 most commonly asked questions that you submitted when you registered to answer during the Q&A. We encourage you to continue asking questions relating to the content you see today, using the Q&A feature available to you. You also have the opportunity to upvote the questions you most want covered today. Please use this tool to help us prioritise the most popular questions. Our presenters, thank goodness, will be helped to answer your questions by a small panel of EPA experts working in the background. We will work through the questions we aren't able to answer today over the coming weeks and commit to making available to you the most frequently asked questions and answers. For questions or comments related to current issues, we won't get to those today, and I reiterate that this session is about the new laws and Council's regulatory role, so please be mindful of that when submitting your questions. Queries relating to pollution incidents or issues should be directed to our contact centre on 1300 372 842. We also won't have time today to answer your questions on Council's role as a duty holder under the Act. This includes some pre-submitted questions we received about landfills, waste transfer stations and resource recovery. If you or your colleagues are looking for information and support, there are plenty of resources available at the EPA website, including 2 upcoming webinars. Today, we have tailored the information to be operationally focused, so you can have a taste of how the new laws will work in practice for you. That means we won't be covering the background to why the laws have changed or the changes across the entire Act. If you would like this information, you can watch our new laws webinar that was held in February this year and is available on our website. We have broken it into chapters with clickable time codes so you can watch what's relevant to you. In preparing councils to assume their powers under the new Act, we have focused our efforts on building council capability and confidence to understand and apply the new powers. We know that capacity and resourcing is a significant issue for councils, like it is for EPA. Just like now, councils and EPA will continue to have to prioritise their work and make decisions about where to direct effort that best protects their communities. The new laws change nothing in this regard. The key tools for building your capability and confidence are 4 new guidance documents. These are all either finalised and published to our website or will be in the very near future. We will be talking through the operational toolkits today. That's the bottom 3 in the diagram: regulating litter and waste, regulating on-site wastewater management systems, and regulating residential noise. When we talked to councils about what they would need to be ready, and we considered the resources we had available and our past experience, we chose to concentrate our efforts on producing these detailed toolkits as the key resources. Of course, there is always more that could be done, but we think these provide a very solid foundation. One of the key changes is that there will be a new delegation to councils. This delegation only applies to on-site wastewater management systems and residential construction noise. There are limitations to who can be appointed and how the powers are enforced. We wanted to upfront acknowledge these limitations and let you know that we are working with DELP on options to address them. There will be more detail in the next 2 presentations on the delegation. And just to be clear, the delegation is not relevant to regulating litter and other waste. EPA is preparing to sign off on a Memorandum of Understanding with the Municipal Association of Victoria on behalf of local government. This is a formal acknowledgement of the important working relationship between EPA, MAV and local government in the protection of human health and the environment from pollution and waste. Also, it provides a framework for EPA, MAV and local government to work more collaboratively and efficiently towards achieving environment protection outcomes for the Victorian community. We thank MAV for recommending to us the MOU, encourage you to explore with MAV how the MOU can work for you, and we look forward to jointly developing some specific and tangible actions under the MOU. EPA has recently added new local government pages to our website. These are a good starting point for accessing the tools and resources we will talk through today. Now we will go to the detailed presentations. Our first topic is on-site wastewater management systems, which include septic systems with a capacity of less than or equal to 5,000 litres on any day. If we reflect on why we are here today, at the most basic level, it's about protecting people and the environment. We know that a poorly managed on-site wastewater management system can cause harm to the environment and human health. We both have a role focused on preventing such harms, made even stronger by the preventative focus of the new Act. Having the right tools to prevent harm is also important. We'll be exploring those tools today. So the key things that you need to know is that the scope of Council's role as a regulator of on-site wastewater management systems has not changed. You currently have a regulatory role, you will continue to have a regulatory role. But the laws and powers have changed. And finally, there are materials and resources to help you to be ready to regulate at 1 July. Councils have an important and long-standing role in regulating the construction, installation, alteration and use of on-site wastewater management systems. This role continues under the new environment protection laws, with councils having additional powers and tools. So what's changed? The new laws have new requirements for the operation and maintenance of systems for owners and occupiers of the land on which it's located. Penalties apply for non-compliance, which councils can enforce. There is better coverage of legacy or very old systems which have never had a permit. And there are new authorised officer powers via a delegation from EPA to councils, allowing councils to take action under the general environmental duty. If you take only one action away from today, it's that you should have a read of the On-Site Wastewater Management Toolkit. It's your go-to resource to understand the new laws and powers. There are 60+ pages of detailed operational information for councils. This is an entirely new document with a compliance and enforcement focus. It applies from 1 July 2021 when the Environment Protection Act 2017 comes into effect. It complements but does not replace the Code of Practice. You will be able to access the toolkit at the EPA website next week when it is published, and we will make sure to let you know when it's ready. EPA has developed this toolkit with councils and for councils. So since the release of the draft Environment Protection Regulations in September 2019, there has been a high level of interest and engagement from councils. We have been working intensively to understand and address this feedback, both by directly making changes to the regulations and by providing support materials. A draft toolkit was distributed to approximately 35 councils and stakeholders in March this year for feedback. The Regulating On-Site Wastewater Management Systems Local Government Toolkit will be published to EPA's website next week. It's important for councils and council officers to understand the source of their powers. Under the new framework, there is a suite of powers for councils and council officers from different sources. There are direct powers under the Act and regulations for issuing permits and regulating the operation and maintenance of systems. There are also powers delegated by EPA to councils, allowing them to appoint authorised officers for specific purposes. I will talk about the delegated powers in more detail later on. Now, before we go into the detail, let's take a bird's eye view of the legislative framework. There are 3 segments: permitting on the left in the dark blue, operation and maintenance on the middle in the green, and then the delegated powers in the light blue to issue improvement and prohibition notices. Sitting over the top is the general environmental duty, which is broad and applies to all activities. So first we have permitting. Councils will continue to administer permits for the construction, installation or alteration of a system with a capacity up to 5,000 litres on any day. The regulations provide criteria for councils to consider when assessing permit applications and the circumstances when a permit must be refused. Councils are enabled to take enforcement action for permit-related offences. Now to operation and maintenance. Following feedback on the draft regulations, a new section has been included in the final regulations to reduce reliance on the general environmental duty and provide greater certainty and clarity for households and local government regulators. This section sets clear obligations on persons in management or control of land on which a system is located. These changes introduce new duties for the operation and maintenance of systems. From 1 July 2022, a duty to notify local government of system failures, a duty to keep maintenance records and requirement to respond to problems, and the ability for local government to order maintenance of a system if it poses a risk to human health or the environment or is not in good working order. This table shows you the requirements for a person in management or control, where an offence applies, and where an infringement may be issued. This table shows you the requirements for a landowner. Apologies. You'll see that for each of these landowner requirements, an offence applies and an infringement can be issued. Prescribed fees are outlined in Appendix 2 of the toolkit. These have been set in accordance with the Department of Treasury and Finance's cost recovery guidelines and informed by public comment. Councils may retain fees for these permit or permit exemption applications. The regulations also allow a council to reduce or waive these fees if the council is satisfied it is reasonable to do so. All councils received detailed information on fees from EPA last year, and this information is included in the toolkit. So, why do you now require a delegation from EPA when you didn't need one in the past? Well, there are a few key reasons. The delegation ensures councils have clear and unambiguous powers that are essential to their role, for example, powers of entry and inspection. It also ensures that a council officer can issue the notice ordering maintenance. This notice can only be issued by an authorised officer under the Environment Protection Act. The delegation also allows councils to access the powers of the General Environmental Duty, the cornerstone of the new Act. There may be situations where the regulations cannot address an impact or harm to human health and the environment. For example, where there is negligence on the behalf of a person manufacturing or installing a system which gives rise to risk to human health or the environment. Or another example might be where a system is operating the way it was designed to and being adequately maintained, but nonetheless gives rise to risks to human health and the environment. While we have done much to prepare, EPA and councils will both be learning as we go, applying the General Environmental Duty. The model endorsed by EPA's Governing Board for the delegation, and which we understand councils are familiar with, is a two-step process. So the first step is EPA's Governing Board makes a delegation, and the second step is that councils then appoint their employees as authorised officers. This gives council flexibility to appoint appropriate roles and numbers of council officers to their situation. The instrument of delegation is well progressed. We expect sign-off in early June. A draft is available for councils to review. If you'd like to review the draft, please place a message in the chat and we will follow up with you afterwards. It's important you're aware of the limitations of the delegation. Councils cannot directly prosecute non-compliance with an improvement or prohibition notice. They'll need to refer this to EPA for follow-up. EPA is currently developing the referral process and will communicate this to councils before 1 July. The second limitation is councils can only appoint employees or a class of employees as authorised officers. Our understanding is this does not include contractors. You should seek legal advice if you have questions on this. EPA has heard council feedback that these limitations present significant operational challenges and may impact how councils use these delegated powers. We have been working with our colleagues at DELP to explore options for addressing these limitations. EPA has prepared the following generic templates for your use: the notice ordering maintenance, the improvement notice, the prohibition notice, and for each of above, a version that can be used for any amendments. The toolkit describes these notices and when they can be used, but does not include the templates. The templates will be emailed to councils directly later in May. We know you'll want to know where the revenue from penalties goes. Councils can retain penalties for an offence under Part 4, which is the permissioning part of the Act. These include offences for engaging in a permitted activity without a permit and for breach of permit condition. Penalties for other offences under the regulations go to consolidated funds. This information about assessment standards was recently shared with councils, and here's a quick reminder. The requirement for an on-site wastewater treatment plant to meet appropriate standards set by EPA, evidenced by a certificate issued by an assessment body, will continue under the new framework. These standards are currently set out in the Wastewater Code of Practice, but from 1 July 2021 will be continued in the regulations. In highly exceptional circumstances involving innovative on-site wastewater treatment plants, EPA may grant to a permit applicant an exemption from this certificate requirement under Section 459 of the Act. More information about the appropriate standards and the transition into the new framework can be found at the link on this slide. So, to recap, there are lots of resources available to you, and here are some of the key ones. You can read the regulations. You'll be able to read the toolkit next week when it's available. You can subscribe to EPA's local government bulletin to help stay in touch with any updates. And EPA has also prepared a fact sheet for owner-occupiers for councils to help use, and this will be coming later in May when the regulations are finalised. So now we have time for questions. We're going to start by addressing the 5 most popular pre-submitted questions that we received through your registrations. Then we'll take as many questions as we can in our allotted time from the live audience. Just a reminder to please use the upvoting feature to help ensure we answer the most popular of your questions. A reminder that this Q&A is relating to on-site wastewater management systems.
Okay, thanks for that, Claire.
Thanks, Will.
The first preloaded question is, will the new laws have any effect on the requirements of council domestic wastewater treatment, domestic wastewater management plans or SEP waters?
Thanks, Will. So when the amended EP Act commences on 1 July 2021, SEPs and WMPs cease to have formal legal status in Victoria's new Environment Protection Framework. Some of the content in SEPs has been translated into more fit-for-purpose subordinate instruments, for example, environmental reference standards and regulations. A limited number of clauses in SEP waters will also remain in force for up to 2 years, up to the 30th of June 2023, under the Environment Protection Transitional Regulation. This includes Clause 29, which requires councils to develop a domestic wastewater management plan. So I think to paraphrase that, it doesn't sound like there are any changes to the requirements for domestic wastewater management plans in the short term.
Thanks, Claire. The second preloaded question was, how do I choose which enforcement path to follow for a wastewater management system that has an off-site discharge?
Yep. So Part C of the toolkit explains how councils can regulate risks and impacts from systems under Victoria's key preventative environmental law, the General Environmental Duty. Appendix 3 of the toolkit provides an investigation flowchart that lays out the options available.
Okay. Question 3, if you're ready for it.
Yep.
How would these homeowners find out what their duties are after the 1st of July?
So EPA, in consultation with the MAV On-Site Wastewater Management Systems Working Group, developed a fact sheet for owners and occupiers of land. It will be published in the next few weeks, we expect later in May, and councils can refer and link to this guidance on their website.
Question 4. What powers of entry do officers have in regard to conducting on-site wastewater management system inspections?
So Appendix 7 in the toolkit lists the powers of entry of an authorised officer in detail. These are fairly standard powers of entry and allow entry to residential premises when certain conditions are met.
Question 5. When council officers have great ideas about how to make the application of a wonderful new legislation faster and more smoothly to improve air, water, land quality, then what ways can the EPA assist in making this happen when resources, finance, research and expertise are stretched?
So this question sounds like something that we could channel through the MOU that we're developing with MAV. I think both EPA and MAV would be willing to hear these ideas, provided they were within the scope of the MOU, which is EPA, MAV and local government supporting each other in our joint regulatory roles.
Thanks, Claire. So we're done with the preloaded questions. We have one question coming up from the chat, which is, can you please clearly explain how the GED is supposed to work for homeowners with split septic systems in terms of discharging to the environment?
Yeah, so thanks, Will. I hope the presentation has gone some way to answering this question. The GED requires the person in management or control of a system, including an older system, to take all reasonably practicable steps to make sure the system doesn't pose a risk to human health or the environment. The key tools are the improvement notice and the prohibition notice. Part C of the toolkit explains in detail how councils can regulate risks and impacts from systems under the general environmental duty.
Thanks very much, Claire. I believe that's all of the questions we have so far. Have you got one that I haven't?
I think I've got one, yeah.
Okay. Oh, yeah, I can see them now. First question is there a legislative requirement for an owner or operator of a system to submit regular maintenance reports to council?
So, thank you experts for helping answer these. There is a new requirement for landowners to keep maintenance records for 5 years. So, for example, these might be pumping out records. If council requests it, the landowners will be required to make it available for inspection.
One more question. So, are on-site wastewater management systems without a permit still able to be used under the new regime?
Yes, is the short answer. Old systems that were not subject to a permit when they were installed can still be used under the new Environment Protection Framework. All right, thank you so much everyone for all those questions. We'll assume that we have been able to answer quite a few of them through the presentation. We'll now conclude this section on on-site wastewater management systems, and we're going to move on to my colleague Will Mosley, and he's going to talk about regulating residential noise. Okay,
Time for our second session of the morning, which will be regulating residential noise under the new Act, the Environment Protection Act 2017. Claire has previously said that my name is Will Mosley. I am an Opal. I previously worked at Casey City Council and I'm currently working at Whittlesea City Council. In my past 4 years in this role, I've had extensive experience working with environmental health officers, planning enforcement officers and other council officers to regulate, assess and resolve residential noise complaints. So in terms of today's session on residential noise, there are three key takeaways. The first is that, like septic systems, the scope of council's role as a regulator hasn't really changed all that much. However, the laws and powers that you will apply when regulating residential noise have changed slightly. And lastly, that there are a wealth of materials EPA is working to produce and has already produced to help local government be ready to regulate residential noise by 1st of July. So what has actually changed? EPA's main change for the 2017 Act is gearing towards a preventative approach. In the past, under the 1970 Act, we had a responsive approach to pollution and waste. Now we want to make sure that all Victorians are obligated to work to reduce their risk of harm before it actually happens. This is mainly encapsulated in the general environmental duty. For those of you interested in the general environmental duty in more detail, there will be a webinar on the 26th of May, which will include a deep dive into the duty, and I encourage you to go ahead and sign up for that. Also changed, the definition of unreasonable noise. Under the 1970 Act, the definition of unreasonable noise was somewhat ambiguous, and we've worked hard to make sure that unreasonable noise under the new Act is clear and has qualitative characteristics which can be objectively measured by council officers. Related offences for emitting unreasonable noise and infringement offences have also changed in the new Act. Thirdly, we have a great new tool, the Residential Noise Improvement Notice. We expect this is going to bridge the gap previously left in past legislation and will be excellent to help council officers get to the root cause of resolving residential noise issues. Lastly, the way residential construction noise is treated under the new legislation has changed significantly. You will now be using delegations from EPA to council to investigate and regulate noise from residential construction. I'll talk a little bit about that later on. Like septics and litter, EPA has worked hard to produce a local government toolkit related to regulating residential noise. This toolkit, we expect it to be your go-to resource, your Bible, if you will, when you're out in the field or plan to conduct an investigation into a residential noise complaint. The toolkit will have information on powers and enforcement tools available to you, penalty structures, some strategies and enforcement action to reduce harm, methodology for assessing unreasonable noise, and some case studies where the above has been applied in real life. You can see a link to the toolkit there, and the toolkit was published formally, officially, yesterday and is available on EPA's website. The toolkit has been undergone extensive development, beginning with when the draft regulations, the draft environment protection regulations were released for comment in September 2019. Council provided significant feedback on those regulations, which EPA then incorporated into the final version. The toolkit was then born of those regulations, and the draft version was submitted to 10 councils for further feedback. All of this has gone in to making this toolkit your go-to resource, and we believe that it will answer all questions you have come 1st of July and make you ready to regulate noise. Additional to the toolkit will be other guidelines which provide more detail on specific topics. The first coming will be assessing noise from residential equipment. Those of you who are familiar with publication 1254, otherwise known as the Noise Control Guidelines, will be familiar with section 1 of this new guideline, which has been redrafted. This time the focus will be on the use of noise characteristics as a determining factor when thinking about compliance. Is it too loud? When does it happen? What impact is it having on the complainant? Things like that. However, these toolkits will still have advice on how to undertake measurements using handheld meters and the like. As I mentioned previously, in terms of local government's role in regulating residential noise, not much has changed. Local government is still primarily responsible for regulating residential noise from residential premises, as well as noise from construction and demolition of residential premises. EPA is still primarily responsible for regulating industrial noise, industrial, commercial and trade premises noise, as well as entertainment venues. And Victoria Police sit between the two, assisting local government in regulating residential premises noise and assisting EPA in regulating entertainment venue noise. Here we have an overview of the sections of the new Act relating to unreasonable noise. Sitting above all is the general environmental duty, which applies to all Victorians engaging in any activity which may give rise to risk of harm to human health and the environment. As I said earlier, there will be a webinar on the GED which will provide detail, so go ahead and please sign up for that. Under the GED, you have specific sections relating to unreasonable noise and the offences. Primarily for residential noise, that is section 167. You then have a whole suite of powers and enforcement tools which council officers and Victoria Police can make use of to take action against unreasonable noise from residential premises. And we also have, like in the past, the regulations which support the Act. In the regulations, you'll find schedules which list prescribed items and prohibited times for those items. A little bit more about the Act in detail. So Part 7.6 is the section or the part which primarily relates to unreasonable noise. In Part 7.6 you'll find Section 167, as I mentioned before, which creates the offence for permitting or causing unreasonable noise to be emitted from a residential premises. Section 171 also relates to the appointment of residential noise enforcement officers, or what we're going to be calling RENOs. And Section 170 empowers RENOs to take proceedings for offences against unreasonable noise. Further down in the Act, you'll find Section 307, which relates to how council officers may issue infringement notices for offences against unreasonable noise. So, like in the past, the Act gives the power to councils and Victoria Police to appoint residential noise enforcement officers, or RENOs. Those of you who are currently authorised under the old Act will be familiar with Section 48A1, and your powers will be similar in function and appointment to the old section. It should be noted that there is the transition provision which enables all of you who are already authorised under Section 48A1 to not need to be reappointed, but are automatically appointed when the new Act comes in. Talking about unreasonable noise in detail a little bit. So the concept of unreasonable noise has changed. Under the 1970 Act, it was ambiguous and was often difficult for council officers to know how to make a decision about what was unreasonable and what wasn't. The definition of unreasonable noise in Section 3 of the Act this time around is detailed. For those of you familiar with the Public Health and Wellbeing Act, this will look familiar, but the characters of unreasonable noise have been well explained and are further backed up in the toolkit. This time we're thinking about things like volume, intensity, duration, when it's emitted and its impact on the complainant or the reporter, as well as prescribed factors. So the definition of unreasonable noise in the new Act means that noise can be considered unreasonable based on any one of those factors, a combination of those factors, and that it doesn't need to meet all of those factors at once to be considered unreasonable. You still have the old pathway whereby noise is emitted from an item which is prescribed in the regulations, and it's emitted during a time which is prohibited in the regulations for that prescribed item. And if it's heard in a habitable room of a complainant's residence, then you would consider it to be unreasonable. We still have that pathway, but we want to make it clear that any noise emitted from a residential premises, whether or not it's from a prescribed item, can still be considered unreasonable if it meets the other characteristics in the definition of unreasonable noise. Fear not though, the toolkit will be your best friend. You might not be able to see it here in any great detail, but the toolkit provides a decision tree which will assist council officers in making a decision about whether or not noise is unreasonable. It should give you the confidence that you may have lacked in the past about making such decisions. So as soon as you can, grab a copy of the toolkit and have a look. The EPA's preferred approach to regulating unreasonable noise and all pollution and waste matters is shown here in this slide. We choose a graduated approach, starting with guidance and support, and only escalating to things like court injunctions or prosecution as a last resort. We would hope that council follow a similar tactic when regulating unreasonable noise from residential premises and construction noise. However, we know that under the 1970 Act, there was a bit of a gap in how you would escalate up this pyramid. You had the 72-hour noise direction and not much before escalating up to the prosecution stage. This time around, we have the residential noise improvement notice. You can see it there, smack dab in the middle of the pyramid. We believe this is going to be an incredibly useful tool for you. By serving a residential noise improvement notice when you find an offence of unreasonable noise occurring, you're going to be able to set the standards for the resident emitting the noise and require that resident to do certain things or undertake certain action. If they comply with the residential noise improvement notice, great, you've solved the issue. But if they don't, then you're going to have a clear basis to escalate further up the chain of compliance enforcement and eventually to prosecution should you need to. We want to confirm today that council will receive revenue from penalties associated with unreasonable noise from the following offences: unreasonable noise from residential premises, non-compliance with a residential noise improvement notice, and non-compliance with an unreasonable noise direction. We'll talk a little bit about residential construction noise now. So under the new Act, noise from residential construction or demolition is not going to be treated the same way as unreasonable noise from a residential premises. However, council will still retain the power to act against noise from residential construction, through a delegation of powers from EPA. EPA will delegate the power to appoint officers under certain sections of the Environment Protection Act, and this will give them certain powers. These officers will be different to residential noise enforcement officers and will have different powers of entry, but the primary power will be the ability to investigate offences against the GED or unreasonable noise more broadly in section 166. As I mentioned, you will have specific powers of entry when authorised under this part of the Act, and you'll have the power to issue improvement notices and prohibition notices when you find offences occurring. The powers of council authorised officers authorised under this part of the Act are further explained in the toolkit, and I want to make it clear that council officers, when there's non-compliance with improvement notice or prohibition notices, you will not have the power to take proceedings for these offences directly. You will need to work with EPA, and EPA is currently working to streamline that process to make it, to enable the process to work effectively between both agencies. Lastly, I just wanted to mention that EPA is working to make you guys a little bit easier in terms of the notices. We have prepared and will be delivering templates for the following: the residential noise improvement notice, the improvement notice and the prohibition notice, which are served when offences against the GED occur, and templates for the amended versions of the above notices. That's it for the presentation, and now we're just going to move to questions again, and starting with preloaded questions that have already been sent through to us. Okay, I have Tim Rose here with me.
Morning, everyone.
Expert in everything noise.
Not quite sure about that, Will, but we'll give it our best shot.
And Tim's going to be answering the questions for us today. So the first preloaded question is, what guidance will be available to councils?
Yeah, thanks, Will. As you've clearly noted through your presentation this morning, but we thought it was worth just fleshing out a bit further. Obviously, the toolkit, which will be, as you've noted, what we hope will be a really great resource for councils who are involved in dealing with noise issues in their municipalities. We really hope that this document becomes the go-to guide for deciphering and unpacking the framework under the EP Act 2017 in relation to noise and the offences process and the compliance process associated with that, and obviously the change in relation to construction and demolition noise. And it provides practical tips and advice for council officers on how they can investigate noise complaints using the risk-based compliance framework of the Act, and in particular provides case studies that highlight the impacts of unreasonable noise. So we do hope that that will be useful. Just wanted to also flesh out a little bit more about the Assessing Noise from Residential Equipment guide. Many council officers will be very used to using our noise control guideline document, which has been around for a number of years now. We've decided to try and make it a bit more user-friendly by breaking it up over time into smaller packaged pieces of information and material. And the first one that we've chosen to do to line up with the release of the regulations is assessing noise from residential equipment. We know that assessing noise from residential equipment like air conditioners can often be something that can be somewhat complex, and we know that that information is useful to councils. As you pointed out, Will, the focus of the entire regulatory scheme is really about dealing with the impacts or the potential impacts before they occur, very much looking at what unreasonable noise is and the characteristics of the noise, and using that within the compliance and enforcement approach. So that's what the fact sheet goes into. It'll be released soon. For those councils who seek to use a more quantitative approach to assessing noise, it maintains the existing measurement criteria that we already use in the noise control guideline for residential equipment, and that will still be there as an option, stepping out how that's how that is used.
What advice is available on the use of residential noise provisions of the EP Act 2017 versus the nuisance provisions found in the Public Health and Wellbeing Act 2008?
Yeah, thanks, Will. Look, we know that councils are very familiar with using the Public Health and Wellbeing Act to deal with noise issues, and they use the nuisance provisions within the Act, and in many respects potentially over time have perhaps preferred to use that Act as a compliance tool rather than using the EP Act. We want to continue to stress that obviously both acts continue to be completely reasonable and separate pathways to use for dealing with local community noise. One act does not override the other. Really, the new act and regulations and the associated guidance that we've put together, I guess, seek to improve the effectiveness and efficiency of our framework, particularly in dealing with sources of noise that are not clearly outlined in the regulations. And in particular those where scenarios occur during the day, which is often a bit complex to deal with. But again, the regulations remain largely the same, and they continue to provide a simple framework for dealing with a significant number of the sources of noise that cause nuisance in a residential setting. On the issue of whether using the EP Act and regulations to resolve residential noise issues meets the duty to investigate under the Public Health and Welfare Wellbeing Act, councils will probably need to consider their own advice on that, but both compliance pathways ultimately are about investigating and resolving residential noise issues.
Thanks, Tim. That's insightful. Question 3 of the preloaded questions. Is there any provision around commercial construction sites?
Yeah, look, good question. Thanks, Will, and thanks for those who were interested in knowing a bit more about this. What's important to understand and remember is that the provisions for construction noise are the same for residential and commercial sites. The proposed delegation relates purely to residential construction noise. The new GED and UN framework is, we believe, best placed to deal with these sorts of sources of noise in terms of construction. And really, this is precisely why we've restructured the definition of residential premises in the EP Act 2017 to allow the use of a modern and flexible, non-source specific regulatory tool, such as the GED, that focuses on preventing noise impacts before they occur.
Thanks, Tim. Question 4. So councils are requesting they need more clarity on what constitutes noise from residential construction sites. Is it sites that are under construction in accordance with a building permit? Or could it be properties undertaking a renovation or upgrade?
Thank you. Yes, look, we've dealt specifically with that issue in the new toolkit, and we've provided a clear delineation between, what is considered, I guess, renovation and what is considered full demolition and construction of a new premises, and hopefully that will be relatively clear and concise in terms of that advice.
Yeah, go ahead and grab the toolkit as soon as you can. Question 5. If councils choose not to opt in to the new Act and the new method of regulating residential noise, can the EPA refer the public and direct them to check the relevant municipal laws?
Well, I think certainly EPA will continue to refer residential noise pollution reports to local government as they do now, and so that situation won't change irrespective of whether councils opt in or not to the delegation.
Thanks, Tim. We have a number of questions that have come in from the chat during the presentation, so we'll try and get through as many of them as we possibly can in the time we have left. The first question is, are the guidelines linked to any enforceable legislation? The guidelines are very difficult to enforce without links back to the Act or enforceable legislation. Relying on other acts, i.e. the Public Health and Wellbeing Act, is not appropriate. They have different requirements for proof.
Yeah, absolutely. Look, the guidance, in effect, links back to our framework. So at the end of the day, the guidance that we've written supports the application of the EP Act and the regulations in relation to residential construction noise, and the options for compliance and enforcement under those or under that legislation. The guidance in itself is not specifically linked to or doesn't have any particular status other than what we refer to as a state of knowledge document in general under the Act.
Thank you, Tim. Okay. This question, will this only apply to residential premises, or can this be applied to commercial uses within a residential area, residential zones, such as hotel? I'm not sure what they're talking about this. They may be talking about the construction noise.
So maybe the best way to answer that question would just be to say that, again, the very deliberate changes that we've made to the definition for unreasonable noise have been to harmonise the way in which we deal with construction noise, whether that comes from a residential premises or whether that comes from a commercial-sized premises. In this instance, the delegation specifically relates to residential premises, but who knows what the future holds in terms of how that might be managed going forward. But indeed, the Act and the way in which the noise framework has been structured certainly seeks to, be somewhat blind to the, the magnitude, if you like, or the type of location where those sources of noise might be emitted from. It's about what those sources are and how they're being managed.
Thanks, Tim. So again, on this question, if the question was the source of noise is commercial in a residential area, could you use the residential noise sections or provisions of the Act to regulate it?
I'd have to probably take that one on notice. I'm not 100% sure. I mean, ultimately, if it's a residential premises, as defined by the definition, then that's how it would apply. But happy to consider the other options or considerations on notice.
I guess we have some comments in the back end which are saying that, say, the hotel or the motel was causing noise in a residential area, that would be considered to be commercial noise.
Yes, it would be.
Yep. Last question. Oh, no, we have more coming in. Okay, this question is, there has been no mention of noise emitted from farming zones. How would these be regulated? Are they residential, commercial or industrial?
So noise from a farming zone is captured by effectively the transition of the noise from industry in regional Victoria. If we're talking the residential premises on a farming property, then obviously it comes in under these provisions. But if we're talking the farming activity itself, then it comes in under commercial, industrial and trade noise. And is dealt with in other sections of the Act.
Thanks, Tim. One question coming in is, I'm concerned with the introduction of the word annoyance in the Act. Can further clarity be provided regarding what is considered an annoyance?
Effectively, the characteristics of the definition of unreasonable noise are what set, if you like, the framing for the consideration of the source of noise that you're dealing with. The toolkit goes into some detail about the ways in which those characteristics can be defined. So I'd certainly encourage everyone to have a look at the toolkit and consider that within the context of such contexts of, as annoyance.
Thank you very much, Tim. We have some further information coming in.
Almost live streaming questions. Yes, and I did actually think that I was a little bit concerned because I didn't actually think annoyance was in the Act, and not actually sure that it is, but we can double check that later.
Thanks very much, Tim. I think we'll move on, as that's the last of the questions we have coming in from the live stream. And so now I'll pass over to Claire Moran, who will introduce our next speaker.
Thank you, Will. Thank you, Tim. Lots of questions there. Great to see lots of interest. And now I will hand over to my colleague Claire Dawson, and she's going to take us through the third part of our webinar today, which is about regulating litter and other waste. Thanks, Claire.
Hello, my name is Claire Dawson and I work in EPA's transformation program, preparing for the new Environment Protection Act. I'd like to thank you for joining us today. It's really great, we've got such great numbers. I've been in contact with quite a number of you over the last 18 months during the development of the 3 toolkits that we've been talking about today. And I'd like to particularly thank those people in Council who have provided feedback to us during that period. That feedback's been incredibly helpful for making those better publications, and hopefully they'll be really good tools for you in your jobs. So, sorry, I should have moved on to, there we go. So I'll be talking today about regulating litter and other waste under the new Act and regulations. So these new laws replace the current litter provisions in the 1970 Act that many of you will be quite familiar with. So the key things you need to know, and this is similar to the other areas we've been discussing, that council's role as a regulator of litter and other waste hasn't really changed. The role and definition of litter authorities and litter enforcement officers remains similar. So EPA, councils and other public entities, notably Parks Victoria, are all litter authorities and who can appoint staff as litter enforcement officers. But the laws and powers have changed a little bit, and we'll go through those today. And of course, there is new materials and resources to help you regulate from 1 July. So the key things that have changed in the litter and illegal dumping space, there are greater penalties for dangerous litter and larger volumes of dumped waste. There are clearer powers and better enforcement tools for litter authorities and litter enforcement officers. The aim of the new framework is to discourage littering and illegal dumping, protect people and the environment from harm, and support livable communities. And these new resources will help you in your role in this. Yep, so the key resource, of course, is the toolkit, Regulating Litter and Other Waste. This is guidance for councils and other litter authorities on how to apply the new litter and other waste laws. It goes through prevention strategies and enforcement action and how they work together to reduce littering and illegal dumping. It includes case studies from councils and from our officers for the protection of the local environment. And it updates and modernises the existing litter enforcement toolkit. And many of you will be familiar with this publication, which is on the EPA website. It's been there since 2014, so this is an update. And of course, the new laws covered by the toolkit apply from 1 July. The toolkit development has been about an 18-month process. So EPA worked with a number of council officers that volunteered to help through the Litter Enforcement Officer Network, who is coordinated by Keep Victoria Beautiful. Through that network, a number of council officers assisted us. We conducted a workshop back in January 2020, and those council officers shared with us what they liked about the current toolkit, what they'd like to see improved, and what they wanted to see in the new publication. Through the drafting, we got a lot of feedback from that group, which was great, and it was published back in December last year. So we'll now get into talking about the new laws. In the waste chapter of the new Environment Protection Act, there's a number of topics. The key one that litter authorities can enforce is Part 6.3, and that is litter and other waste. So this graphic here shows how Part 6.4 specifically is implemented by litter authorities, including EPA, councils, and other litter authorities like parks. So looking at how EPA does this, so EPA provides a public reporting litter hotline and app where members of the public can report litter deposited from vehicles. And EPA also investigates illegal dumping of industrial, hazardous and large quantities of waste. And EPA investigates suspected repeat or illegal organised or illegal dumping issues. EPA can use Part 6.4 of the Act that we've been talking about, and we also have additional powers under the industrial waste laws. So councils and other litter authorities also have the same powers under Part 6.4 and can investigate and take action regarding litter offences and also larger scale illegal dumping too. So litter and illegal dumping, as you know, is a big problem in our community. And a combined regulatory effort of EPA, councils and other litter authorities is essential to tackling it. So we'll just bring this definition. Okay, so here we have the new definition of waste under the new Environment Protection Act. So it's a pretty general and broad definition, and you can read it, of course, in the Act and also in the toolkit. And then we see a change regarding the definition of litter. So litter fits into the Act's broad definition of waste, but it's now a volume-based definition, and it means waste less than 50 litres in volume. And here we go, some graphics to show you what that might roughly look like as a point of reference. Now, the key main offences under Part 6.3 of the Act are for unlawful deposit of waste. And so deposit of waste occurs when a person parts with possession of litter or other waste. This can include burning of waste and where waste blows or falls or escapes from a premises or place. And the offences, section 115 is the key there. The offences are broken up by volume of waste as well as type of waste in the case of dangerous litter. And here you've got highlighted the 4 different key offences for litter, dangerous litter, 50 to 1,000 litres of unlawfully deposited waste and more than 1,000 litres. So these are all infringement offences and can also be prosecuted in the Magistrates Court. So now that we've got these volume-based offences, estimating volume of waste in an illegal deposit will be key to investigating. So to work out which offence may apply, LEOs will need to investigate the volume of waste or the total volume of a connected series of deposits, which the Act also allows for. There are a number of resources in the toolkit which will help you to do that. So in some instances with smaller volumes of litter, you know, a couple of items, it's going to be pretty obvious if it's less than 50 litres. But where you've got waste that could be, you know, around those threshold amounts between 50 to 50, tipping over 50 or just under 1,000 or just over, accurate measurements are going to be required. So as I said, the toolkit has a number of great resources around measuring and making calculations. So please have a look at that. Okay, and we'll go and have a look at the penalties associated with each of the offences under section 115, so littering. So this is less than 50 litres, so large penalties than they are now. So the infringement, the court offences and infringement offences are divided up between, for an individual, which is, you can see there is the infringement amount is 2 penalty units, or for a body, corporate or company, which is the 10 penalty units. So that's how they are shown there. And a person must not deposit dangerous litter, and it is a higher offence for dangerous litter. Okay, so we'll just look at what dangerous litter actually is. Right, so dangerous litter means litter, again, less than 50 litres, that's wholly or partly comprised of one of the following, and this is a definition from the Act. So you can see you've got pictures there, glass, syringes, cigarettes, small, solvents, paints, those kinds of things. In addition to these waste items, it's any substance, material or thing prescribed by the regulations. So how that works is under the new Environment Protection Regulations, priority wastes are listed in Schedule 5 of the regulations. So generally EPA regulates priority wastes, but where they are unlawfully deposited in volumes less than 50 litres and from an industrial source, they are considered dangerous litter, and litter authorities, including councils, can take enforcement action. And this is now one of the larger offences, so 50 to 1,000 litres. As you can see, we now have got those larger penalties associated with them, which are more proportionate to the offence. And that's what it might look like in terms of volume, a few wheelie bins. Okay, and more wheelie bins, here we go. More than 1,000 litres, which is the largest offence, and you can see much greater penalties there, infringement of up to $8,000 for a body, corporate or company. Right, so many of you here today will be appointed as litter enforcement officers currently, and that appointment rolls over or transitions automatically under the new Environment Protection Act. So if you're currently appointed as a litter enforcement officer, you don't need to be reappointed. It'll just be people new officers after July 1 that will need to be appointed specifically under the new Environment Protection Act. So the powers of litter enforcement officers are fairly similar. They can be appointed by litter authorities, of course. So councils, of course, can appoint staff as litter enforcement officers, be that in your local laws area or other areas. They have powers under the Act to enforce the litter and other waste laws. So litter enforcement officers include EPA authorised officers and police. In terms of jurisdiction, EPA and police have statewide powers to take action under Part 6.4. Council LEOs can act within their municipal area, and LEOs from other litter authorities like Parks Vic can act in relation to lands under management or control of the agency. So you'll see for councils, that's a change in the definition and should give you more clarity as to your jurisdiction around litter and waste. The powers, again, are not dissimilar to currently. Powers of entry to non-residential premises. A LEO can ask a person's name and address in relation to a litter offence. They can request a person remove waste. There's two new notices, the Waste Information Gathering Notice and the Waste Abatement Notice. I'll talk a bit about those in a moment. There's infringements associated with unlawful deposit of waste, which I've already mentioned, and there's also infringements associated with non-compliance for those other things like requesting person remove waste and non-compliance with the notices. So the Waste Information Gathering Notice can be used by a litter enforcement officer to obtain information about waste they believe has been unlawfully deposited. It allows a LEO to collect evidence that may be used to take enforcement action. And as I said, it's an offence not to comply with this notice. So it's similar to the 45ZI that you'll currently be familiar with if you work in this area. And then we have the Waste Abatement Notice. This is similar to the Litter Abatement Notice, but of course can be used for, across all different types of waste. It can be used to manage waste or material that may become waste and ensure it's deposited in a lawful way. It can require a person who deposited the waste to clean up, restore a place that's been impacted by waste, lawfully dispose of the waste, or change their activities to better manage the waste. It can also require the occupier of a premises to clean up or dispose of the waste in a situation where the responsible person can't be located. And like in the other presentations, I'm showing here EPA's escalating approach that we recommend to take enforcement action. You can see those compliance enforcement tools there, the notices, infringements, and so forth. But education prevention is always the best starting point. So in addition to the Environment Protection Act, the Environment Protection Regulations, which will shortly come into be made, add some additional offences in the litter and waste space. So some of these offences will be quite familiar to you. They are largely carried over from the current Environment Protection Act, but instead of being in the Act, they're now in the regulations. So they include defacing, setting fire or damaging a bin, depositing or affixing unsolicited documents, commissioning and engaging in distribution of unsolicited documents. So like with the Act, litter enforcement officers, litter authorities can take action in relation to these offences under the regulations. And we also have notice templates, like for residential noise and for septics, we have notice templates for you to use for litter and waste as well. So for the Waste Information Gathering Notice and the Waste Abatement Notice as well. So I've got there, if you can see it, the front cover of the Waste Information Gathering Notice. It's a few additional pages, but the top right-hand corner, there's a place where you can, council can tailor them by adding your own logos and so forth and contact details. But these are very similar in substance and in look to the Waste Information Gathering Notice and Waste Abatement Notice that EPA will be using as well after 1 July. So penalties for offences are retained by council under Part 6.3 of the Act. Okay, so I'm going to now talk about EPA's Waste Crime Prevention Directorate, which is a new directorate. This team have asked me to convey a bit of information about who they are and what they do and how you can work with them. So the new Waste Crime Prevention Directorate was created to reduce risk of harm to the environment and the community through effective prevention, detection and enforcement against waste crimes. They've got 3 units, a compliance and enforcement team, compliance enforcement unit that has a number of multidisciplinary teams, and there's a waste crime programs unit, which is strategic programs around prevention, surveillance, intelligence, planning and projects, and a chemical waste and recyclable materials compliance and enforcement unit. So this unit is focused on regulating businesses whose operations may pose a fire risk. So generally this will be larger businesses that may have a council planning permit and will probably have an EPA permission under the new Act. How you can work with this team or this directorate. Please report information to EPA about multiple dumpings of industrial waste or things like asbestos contaminated material. And also where that dumping may be happening between local government areas. Evidence of stockpiling of waste or properties, and this might be with or without a council permit. Skip bin waste management or chemical storage operations. And known or that may have a waste crime element that may have come to your attention. Known operators with a history of waste crime dumping that are known to your council, and any other information that you have around waste crime that you think would be relevant to EPA. So members of this team have put their names down there. You can contact them if you wish to report anything or talk through any incidents. You could also contact your EPA regional office or your OPAL as well if you're a council lucky enough to have one. Okay, so resources. We've got the Litter and Waste Toolkit. That's available. Hopefully a lot of you have had a chance to read it. There's our local government bulletin, which the other presenters have mentioned, and a link there to EPA's public reporting hotline as well, where you can report litter from vehicles. And a link for the Litter Enforcement Officer Network, or LEON, to their website too. And they are running some training on the new Act coming up, so you can go to the website for information there. Okay, so that's the end of the presentation, and we have some questions. While I am loading those up, I'll introduce my co-host, Drew Marsh. Thanks. Drew is going to assist us to answer your questions around litter and waste. And Drew is a regulatory specialist. Some of you will have probably seen or heard from him in the past recently around the new Act as well. So we've got 5 questions that were preloaded. And the first one I'll just address quickly. So with councils, so the question is, with councils that have OPALs, will the OPALs receive the same delegations as council officers, particularly as it relates to litter and waste? OPALs are appointed by EPA's authorised officers, so therefore they have the same power, they have all the same powers of litter enforcement officers automatically as authorised officers. So they don't need any additional appointment, they have the same powers there. And I have a question now, has there been a material change to the 45ZI process? And I will pass that one to Drew.
Thanks for that question, Claire. So the short answer is no, there's no really material change. It's really an update or a transfer of the existing power. What is different though is the infringement that is associated with non-compliance. So it is a higher infringement. So essentially what we're saying there is that it's a serious issue if you don't answer the notice as set out. So placing greater importance on those who receive the notice to participate with the important investigation processes that you need to fulfil in order to administer your part of the Act.
Thanks, Drew. Okay, so the third question is, when will the templates for the notices be available? And like with the other templates we've been talking about for residential noise and septics, we're going to send them directly to councils within the next couple of weeks. So they're all done and ready to go. We were just waiting for the toolkits to be published to support them, so you've got some context to their use, and they will be all made available directly. So the next question, Drew, is are there any changes to infringements for larger amounts of litter?
Yeah, absolutely. Now, this is a material change, and this really recognises the overlap that arises between the councils and other organisations' responsibilities for addressing waste crime and litter and larger levels of dumping, and EPA's ongoing role with coverage over the state of Victoria. And what these offences really do is try to recognise that the litter infringement under the current Act doesn't really adequately address some of the larger scale dumping that occurs across Victoria. And so these new classes of infringement, which are volume based, are really there to give councils and other organisations that are delegated these or that have powers under this Act, the new Act, to be able to better tackle those crimes in a proportionate way. And so what this means is, while there'll be still an ongoing need for you to interact with EPA, particularly where it's industrial waste or where there's more systemic problems, for some of the larger volume dumping that occurs routinely in your areas, there are offences that are much more proportionate to the scale and the impact that those offences have.
Thank you very much. Okay. And a final question that was submitted prior to the session is, are litter abatement notices still going to be used?
The short answer is yes, but not by that name. So the waste abatement notice is the successor, if you like, but it really covers a lot of the same grounds. It applies to someone who's deposited the waste unlawfully. The scope of what you can do with that is, of course, to require that the waste is cleaned up and that it's sent to somewhere that can lawfully receive that type of waste. It also allows you to direct someone to restore the impacted area, which can be quite important where there's an amenity value that has been harmed by the dumping of that waste. And then perhaps even more important and more in keeping with what the new Act is really focused on is an ability to issue directions around modifying the behaviours and the activities that actually cause the waste to be dumped, or to be deposited. So that really gives officers an opportunity to take on a preventative approach. So particularly with routine issues that you see time and time again, the notice will actually allow you to break that cycle in a way that can be compelled under the notice.
Thanks, Drew. Okay, so that's the end of the questions that we previously received, and we've had a few come through, so thank you. I can see that a couple have been already answered in the chat, I think. One of the questions, so we've just covered that one. So what is the time frame around the new template? So we just had a chat about that. Okay, so this is another question. Okay, what about when litter originates from a business activity? For example, a landowner prohibiting smoking on their land, causing cigarette butts, litter on public land, clothing bins, requesting donations when they are placed on public land rather than in a bin. Can councils fine landowners?
Well, so the short answer is probably. It comes down to the offences that are set out in section 115. And so provided the elements of the offence can be identified, so the deposit of litter, which is defined to be waste less than 50 litres, then there will be scope for you to be able to issue those offences or those infringements. Same with cigarette butts. Judging by how the question's been framed, it sounds like it would be within scope of your powers. There's perhaps an additional element to that kind of hazardous behaviour where you may also want to inform EPA if you feel that there is a risk of harm associated with it. So it's probably important to note that while some of the challenges that you face are better addressed by the new infringements, particularly the volume-based, there may still be cause for you to raise concerns with EPA if you see particularly systemic problems that relate to creating a risk of harm, because of course the general environmental duty is a concurrent obligation on businesses and will require them to eliminate risks of harm through their activities. In terms of the clothing bins, I think this is a bit of a perennial issue, and I think, look, provided you are able to satisfy the volume-based aspect to the bins, I think infringements will be available there. Of course, given the nature of that context, there's probably a conversation that you might want to have with those operating the bins as well, because they obviously fulfil an important service. So there's a bit of a balancing act as to how you exercise your discretion. But we recognise it as dumping or as unlawful deposit, and there are probably steps that the organisations responsible for those bins can take to reduce that risk, but using infringements may be appropriate, particularly where you can obtain evidence of the commission of those offences. So it's not outside of the scope. I think probably from an evidence point of view there may be challenges in sustaining an infringement there, hence why solving the problem through consultation may be an additional approach to that issue.
Thank you. Okay, so we've got a question around dangerous litter and what might be considered dangerous. So what about dumped car gas tanks? Is that considered dangerous litter?
So dangerous litter has two components. There are a set of explicit categories of dangerous litter set out in the Act. Judging by that the way the question's been placed, it's a question as to whether or not it would contain flammable. If it has residue in it, it may be regarded as having fitting within the Act definition. But in this particular instance, I'd also recommend you look at Schedule 5, because priority wastes are also covered by the incorporated through the regulations into dangerous litter, and it may well be that a container with flammable residue in it may also be regarded as a dangerous litter within that definition. I think there's probably a question here around the most efficient way of addressing the problem, and it may be more technically challenging to pursue that. It is a higher penalty. I think it's a bit over double the standard Section 115 offence. It'll be up to you to decide what you think is the most appropriate, but if there is residue in the tank, I think there's probably a good starting point for characterising it as dangerous litter.
Fantastic. Okay. We have one more question. Okay, so it's around cigarette butts. So an unlit cigarette butt is not deemed dangerous. Why is the fine so high for something so small compared to other small items, such as a bag of dumped waste? So unlit cigarettes are...
Yeah, so I think, look, the question around the policy choices behind this, there's a level of pragmatism, and certainly cigarette butts are identified as dangerous litter on the basis of their potential for contributing to bushfire events. However, that said, there are probably a huge variety of matters that may well have been expressed in the Act and certainly can be included down the line through the prescription option under the regulation. So I think for the time being, what we've done really in this first iteration of the Act and its regulations is to translate what was an existing practice into the new approach. If in the course of administering this Act, and there will likely be reviews on the regulations periodically, if you feel that the approach is not proportionate or there are gaps, then there's always an opportunity down the line for you to raise those with us. I think for the time being, though, the lit cigarette and the cigarette butt is regarded as having an inherent risk of harm associated with it, hence why it's been prescribed as dangerous litter.
Thanks, Drew. That's fantastic. Okay, so that concludes the questions around litter and other waste. I'll hand back now to Claire Moran.
Thank you, Claire and Drew. Now we are running a little bit ahead of time, which is good. So what we're going to do is to try and keep answering some of the questions that have come through. And we did have a question about questions. The question was, are you going to answer all the questions that come through on the chat? So later on. So we will absolutely do our best to do that. If it doesn't get answered today, we will absolutely try and follow up. If there are questions that we feel have been addressed in the presentation, then I guess we really encourage you to look back over the presentation to sort of self-serve for some of those answers, because I'm sure you can imagine there's a lot of questions coming in. So what I'm going to do is I'll just read through some responses, and if I need an expert, I might just perhaps call them up to give an answer. So regarding on-site wastewater management systems, we did have a question that came through, which was, will property owners be required to renew their septic tank permit every 5 years, and how will that process work? And the answer was no. An on-site wastewater management system permit is for the construction, installation or alteration of a system. So I guess I take that as meaning it's a point in time permission and it doesn't last over a period of time. I will also just go back to the question that we had in noise about annoyance. So we had a question that was, I am concerned with the introduction of the word annoyance in the Act. Can further clarity be provided regarding what is considered annoyance? And the answer from our experts is that annoyance is not in the Act nor the regulations. And the factors cover the factors of unreasonable noise. Okay. So a question about opals. Will there be an expansion of the number of opals available to assist councils? And the answer to that is there are no new opals have been announced at this stage. Another question here, this is related to on-site wastewater management systems. In what scenarios will councils need to transfer a permit? So where a change in permit holder is planned prior to completion of the work, for example, where the property owner is the permit holder and sells the property. So we also have a question here that's related to the delegation of powers. The question is, will the instrument of delegation apply to Alpine Resort Management Boards? And the answer to that, I guess, initially is no. Our focus in terms of making the delegation is to councils, because that's where we understand the greatest need for these powers are. But we certainly would be happy and willing to reach out to Alpine Resort Management Boards following 1 July to look at the case for why perhaps they might need these powers. Got some more question here. Okay, this is a question again also related to the delegation. So what is the logic behind the councils being unable to take further action for improvement notices and prohibition notices issued under the general environmental duty? Is this placing more work on the EPA to take all of these on and causing double handling or time delays? So, having not been, I guess, involved in the writing of the Act myself, I probably can't give a super clear answer, but I guess I would say that there are significant new powers in the Act, and when the Act was going through, I guess, the many layers of approval, there was very close scrutiny of the powers themselves and also who would be able to access them. And I guess, yes, the referral of this enforcement action to EPA, I guess ultimately it will place more work on EPA to take these on. And yes, I guess it could cause double handling and time delays, but as we said earlier, we are working on a referral process to try and make it as efficient as possible, and also to be clear to councils about what cases we would take on. So we hope that will try and address, I guess, some of those concerns. Another question about the instrument of delegation, timing. If councils are delegated these powers in early June, that might be a problem because council officers needing new authorisation with the new Act will then have to wait for 30 days until the next council meeting with no powers. So yes, it's correct that we will have the instrument finalised in early June. Absolutely acknowledge that's getting very close to 1 July. I guess a couple of things I can offer there are that we have a draft of the instrument which we're happy to make available to you now if that would assist you in preparing for the council processes you need to go through. And the other thing I'd say is that I guess remember the delegation I guess complements a lot of the other direct powers that councils have. So it won't necessarily be the end of the world if the delegations are all not made on 1 July. I think we need to allow ourselves a bit of room. A question on will councils be trained how to write, amend or revoke notices? And I guess we don't have, Sorry, I'm going to throw to Claire to answer that one.
Thanks, Claire. With regards to notices, so the toolkits, thank you, where the toolkits do cover a fair bit of detail around how the different notices can be used for residential noise, septics and litter and waste. If there is a need for councils, if we get feedback that it's not detailed enough, that you want get more in-depth guidance on writing requirements, for example, we'll look at doing that and providing that to you after the 1st of July. So acknowledge that that some further support might be in store in that area.
Just on the question about opals and whether or not there'll be any further rollout of opals to new councils, I can't confirm that there'll be any further rollout in the immediate future. But we're optimistic that the Opal program, the Opal pilot program, will be made a formal program come the 1st of July, which means that we have scope in, maybe not in the immediate future, but in the future to eventually expand the program based on government funding. In terms of the question, we had a question, will council receive any extra resources to manage noise investigations? EPA has run 2 years of training programs for environmental health officers, planning officers and other officers involved in noise investigations, and we've managed to train upwards of 20 councils. Due to the extensive transformation effort spent on transformation in 2021, we don't have any planned training this year, but we intend to continue this training in the future. When resources become available again. In terms of opals being available to assist councils, when you have an opal, that opal will be available, and please continue to watch the opal space, and should an additional rollout occur, submit your applications, your expressions of interest to get an opal.
Thanks, Will. I've got one more question and one more I'm going to take as a comment before we'll close out. So we're taking this one as a comment. Thank you. We need to ensure EPA information does not give residents unrealistic expectations, given that a number of councils are looking to leave enforcement of unreasonable noise to the police. So we'll take that as a comment. Thank you. And the final one, so again, going back to the delegation, improvement notices and prohibition notices not being able to council to not being able to enforce these. So the question is, given council officers will be undertaking initial investigations and evidence collection, will training be provided by EPA regarding evidence collection, type of evidence required, etc.? So I guess I'd say to that these are the type of issues we'll need to consider in the referral process. Being clear to councils about sort of those things, what types of evidence would be required. I would also say to you to please look at the toolkit, because remember, there are many parts where council can enforce and they can initiate prosecutions in their own right, and there's detail in there about conducting investigations on those. So, thank you all so much for your attendance and attention today. We know that we've provided you with a lot of information, so we really encourage you to take some time to digest the materials, to visit EPA's website, and also, of course, you'll be able to go back and listen to this recording. I'd like to thank my fellow presenters, so Will and Claire, and also Tim and Drew. And there's a whole backhouse team making this event happen, including our experts, our comms and engagement crew, and our tech team here making it all happen. There will be a survey coming to you very shortly about this webinar, so please complete it and let us know how we've gone today. And I guess finally, I would just say to you that 1 July is really just the beginning. And as much as we prepare, we know that there will be bumps in the road, but it is just the beginning, and we look forward to continuing the conversation with you and the fun bit really, which is implementing these new laws. Thank you.